Welcome to this webinar on data protection and privacy. I'm your host and moderator, Helen Ambassa, Director Legal Services at USIU Africa. I have with me Kananu Mutea, Advocate, and Felix, both from Gikera and Vadgama. And I also have with me George Galande from Galande Consultants. And of course, as usual, I have Salome Asena. I like to call her my trooper in the background. And John Sunday, our digital media specialist. I'm very grateful for all of you for being here today. And this conversation, I know this is a very heavy topic, very wide, but we hope that within the 2 hours, we will have at least delved a little bit into what safeguards we need to put in place in as far as data protection and privacy go. I see so far we have around 18 participants. So with the permission of my facilitators, I will begin. But just before I begin, I'd like to thank USIU Africa, without whom we would not be holding this webinar. We started this as a way in which we could disseminate issues, topical knowledge on legal and governance issues to not just USIU family, but also to our partners. So we are most grateful to the university management for providing us this opportunity. So I'll delve straight into the issue at hand today, and it is really to discuss data protection and privacy. So I'll start off with the question, what is data protection and why is it important? Kananu.
Thank you. Thank you so much, Helen. This is a very timely topic, given that Kenya is just getting on board with this legislation. So to answer that question on what is data, I think I'll want to focus on the data that the law seeks to protect so that we then have proper context of this. So what we talk about when we're looking at this data protection, it's really personal data. And this relates to an identifiable natural subject who has personal data in the way of, the name, the race, health status, ethnicity, beliefs, religion, biometric data, family details about your marital status, names of your children, your parents, your spouse, your sexual orientation. I think now we are seeing forms that are asking for us to provide this kind of information. So everything touching on information that can identify a person is data. And this is the kind of information that the law seeks to protect. Now, to that next question, Helen, I will answer. The reason why we need this data protection is to safeguard the use of personal data by entities that collect, store, alter, or consult on the use of this personal data or communicate with this data. Now, the idea behind these protections is to ensure that there are safeguards for that person whose data has been collected by an entity, and the entities can be varied. These entities, I think for most of us, if not all of us, when we go shopping now, of course, we'll be asked for our telephone numbers, your name, sometimes ID number. When you're going into some buildings, they might take your facial recognition, your image as facial recognition. They might take your thumbprint or fingerprint. So all this information is being collected from us from very many sources. And the idea behind data protection is to safeguard that information so that it is not subject to abuse.
Thank you. Felix, do you have anything you want to add to that?
Okay, thank you very much, Helen. Not really. I think Kananu has given a very good introduction covering what personal data is. And I think we will get to get better perspective to what it is as we will go along.
Okay. So now that we've identified, what data protection is and why it's important, I'm just thinking somebody out there may be wondering, so what are the ways in which we can protect data? You know, what are the types of data protection?
So yes, so I think that's a very good question, and it speaks to the, I think for starters, speaks to the type of data that any particular organization is handling, and the mode of processing that data. Kananu has just explained that the term processing of personal data is quite broad, and it covers, amongst other things, receiving the data, storing it, analyzing it, sharing it, and all other aspects of dealing with that data. So to answer the question, how do you protect the data? So the first question you ask yourself is, how do you process it? So if you're storing it in a manual form, you want to ensure that the integrity relating, for example, to access of the document is top-notch. You want to ensure that the storage is secure. You want to ensure that all access related procedures are well outlined and restrict access to the data, amongst other things. And the same principles and approaches would also apply if the data is stored electronically and if it is processed electronically. And I think that's more or less the most common form of processing of data. So in brief, you'd want to look at how the data is processed, and then based on that, determine the approaches that you want to come up with to set up a mechanism for protecting it. And I think we'll get more into how that protection can be achieved.
Okay, so I guess at this point is where we'll talk about stuff like authentication, encrypting. I know it's a bit technical, looks like we are going into the IT side, but I'm sure the participants would like to hear more about that as we talk about, integrity and processing of personal or even institutional data. Now we know that Kenya has recently enacted a Data Protection Act, and it is mostly modeled along the EU General Data Provision Regulations. Do you want to speak to that just a little bit so that we get into, from the Kenyan perspective, how are we looking at safeguarding data and privacy?
Super, thank you, Helen. Very good question. You see, most of our legislation, and we do remain somewhat attached to our colonial powers. So we tend to follow a lot of what the UK does in terms of legislating. And you're right, the Kenyan Data Protection Act is pretty much, Felix, I think you'll agree with me, it is pretty much a mirror in the protections that it seeks to give data subjects, and also the restrictions that it imposes on businesses in terms of the use, the processing, the storage, collection, and retention of subject data. So, and I think when you look at the rationale behind why the GDPR was put in place, and indeed even for Kenya, why we thought to put it in place, there were the incidents. I think more recently, what I can recall is the Cambridge Analytica incident that occurred with the data breaches, and this was in the American elections. So there were things like those that have happened globally, where mega corporations, Facebook, they're all involved in aggregating so much data that then is subject to abuse. You've spoken of encryption of data. While we're not techies in the subject and cannot therefore talk of the high levels of encryption that are expected to preserve data, there are those basics that will be expected of any business looking to collect data in order to profit off of customer retention. So while the encryptions, strict encryptions in the way of banks and entities that are really entrusted with higher levels of personal data. So for example, as I was talking of what your personal data is, your name is one thing, but your name linked with your financial net worth, those you might want people to know your name, but you might not necessarily want them to know your net worth. You might not necessarily want them unnecessarily to penetrate into your sources of income. So when you look at how financial institutions will be considered globally, actually, not just in Kenya, in terms of preservation of that kind of data, it's a much higher standard. So you then have the FMCG sector, the Carrefours who collect your information, and the Naivases who give you loyalty cards. So those ones, of course, the threshold will not be anywhere near banking. And this is true when you look at the application of this legislation in the EU, but the expectation is that they will not mishandle your data or use it for purposes other than those which you have intended. So when you look at it from the data subject perspective, this legislation is supposed to ensure that when you go to a vendor, for example, a seller, or let me say a supermarket as a broad example. When you go to that supermarket and you buy a product, you know that what you've gone to do is to purchase an item. You might want to be a repeat customer. And so when you're giving them that information, you're doing it specifically for that purpose of acquiring items from them. That is very distinct from you, for example, going to your bank or an investment advisor where you're expecting them perhaps to send you periodic information on investments in the market trends. So the use of your data by different entities will lend itself to different protections. And this is just something to bear in mind because, Helen, you had asked the question, how can an individual safeguard their data? And from where I sit and looking at the history of this legislation, the data subject must have some degree of consciousness when they're providing this information. So the data subject has to be careful in releasing this data. Now, just to contextualize, as I even speak a little bit more of why data protection from a business perspective is useful. A data subject, when they're giving out this information, they need to be wary of what we're trying to ring fence or the safeguards, why these safeguards are being put in place. It is because, of course, we have seen the abuse of personal information. I think in Kenya recently, what we had was people finding themselves registered as members of different political parties to which they had not subscribed. And the question here is, if I have your ID number in Kenya and I have your PIN, that's your KRA personal identification number, and I happen to have your 3 names, because in Kenya we tend on average to have about 3 names. So you see, if I have that basic information about you, then you need to ask yourself, how much more can I obtain? Can I get to know your phone number? Can I get to know your place of residence? And if I have your phone number and your name, then how much can I know about you? So the data subject has to be careful about the information that they release and to whom they release it. So now to a business perspective, Helen. Businesses, I think it is in their own self-interest to make sure that they treat this information that they're given carefully. Mistreating of information, and we have seen this when there was a huge flight. I think people started saying that WhatsApp is not secure, in spite of the fact that WhatsApp says that they are end-to-end encrypted. So many people moved to Signal, and now I see many pop-ups telling me my friends are on Signal. So that move was actually occasioned by people feeling that their conversations were being listened in on, or that there was a way in which the messages perhaps that they intend to be private can be violated. So this did not give the users, the exclusive users of WhatsApp, comfort. And this again, if you recall, it is linked to Facebook. So there is all that question of, if you preserve data as a business, the integrity, customer retention, these are things that a business can derive. Then you look at brand value. Your value goes up. Signal, I don't think expected that kind of update, but there we are. They now have more subscribers than they did before. And it's important to know that data breaches can hurt businesses with this kind of exits. And also, I think the last thing that I'd say about the benefit of this kind of legislation and it coming home is the question of businesses supporting ethical treatment of the consumer. And the consumer, of course, in this scenario is all of us, because all of us, whether we're the business owners or the consumers of service, at some point, we alter our positions in terms of what we're expecting the society to provide us. So I think for me, this legislation is also about supporting ethics. Helen, I hand over to you. Thank you.
Thank you, Kananu. There's something you've said, there's an expression you've used that I thought perhaps you may want to define it. Data subject, I've had data subject, I've had data processors. If you don't mind, defining what that means. I'm sure there's a participant somewhere who's wondering, data subject, what is that? Is it me? Is it USIU Africa, the entity, data processor? So who does the law define as a data subject, and who does the law define as a data processor, and the roles that each of them play? And I also wanted us to, I just want to throw this out there. I know data protection and data privacy are used interchangeably, but is there a distinction between those two? I can see George moving around on his seat. I know he's really yearning to talk to us about, the risk imperatives that despite everything we do, there still is a risk that there may be a breach. So George, we'll get to you shortly. Yeah, so and Felix.
Okay, I thank you, Helen. I think I'll invite my colleague Felix to answer that on who the data subjects are and specific persons who handle, who are protected and their expectations in respect of from this legislation.
Thank you very much, Kanan. So maybe pull it up. Okay, yeah, right. So I think the Data Protection Act, sets out a number of key definitions which form the basis of the legislation around data protection. So I think I'll mention a couple of them, starting with the one that you just mentioned, the data subject. So the Act defines a data subject as an identified or identifiable natural person who is the subject of personal data. Simply put, that is the owner of any personal data, or any person that can be identified directly by reference to any type of personal data relating to them. The key distinction here is that this is a natural person, and therefore a legal entity cannot be a data subject. We have another key definition, a data controller. The Act defines a data controller, and I'll paraphrase this to mean any person, and this includes any entity, that determines how personal data will be processed. Key thing to note is that this includes public or state or governmental bodies. So that's a key thing to note, particularly because government does collect and process a lot of personal data. Another definition to note is a data processor. You will find that in quite a number of instances, the data controller will share the personal data that they have with a third party. That party, when they receive that personal data and do with it anything that amounts to processing of the data, qualifies as a data processor. And the Act sets out a couple of provisions that regulate how that data processor should behave in relation to their handling of that personal data. So I think those are some of the key definitions that we probably want to touch on as a preface to the other discussion that we will have.
Yeah, so Felix, if I hear you correctly, you're saying that a data subject does not include a legal entity. So USIU, for instance, would be classified as a data processor?
USIU would qualify as first, if depending on the role they are playing in relation to a particular set of personal data, would qualify as a data controller. So if USIU collects information, for example, from a student and decides how that data will be stored and the purpose for which it will be stored or shared with another person or analyzed, then that qualifies USIU as a data controller. If USIU stores this data by way of illustration, say on the cloud, with an example, just use an example, Amazon Web Services. So they'll have effectively shared that data with a third-party AWS. Now, AWS will qualify as a data processor, and they will handle that data subject to the agreement that they have with USIU. Okay, you'll find that in certain instances, USIU will play the role of a dual role of both a data controller and a data processor. So I think that's key to note.
Yeah, why I'm asking that question is, and now we are going to delve a little bit into research. So if I'm a student pursuing, say, a master's degree, and I want to base my study on a particular entity, and I'll choose, let's say, a telco or a bank, and then the bank decides that we must sign a non-disclosure agreement with, I'm using USIU here, because it's USIU, right? So we have to sign a non-disclosure agreement with USIU. And within that non-disclosure agreement, there are clauses on indemnity that if there's a breach, USIU will indemnify this banker or telco. So how effective is that sort of protection? Because that's another way that you protect data. They are looking at institutional data. And within that institutional data, there may be personal data. So for instance, if it's Safaricom, there could be our data, our numbers, our ID numbers, all that stuff that as a student I might encounter in the course of my research. So both Felix and George will come in here, So how do you make sure that you satisfy this student's requirement to complete their course of study and also safeguard the interests, not just of USIU, but of that telco or bank?
Okay, perhaps I can go first. So I think the first thing to note is that the data protection legislation does not restrict or does not necessarily impose any restrictions on the processing of data by any person. All it does is that it imposes certain protective measures towards its protection. So that, I guess, is the starting point. In the context of an engagement between USIU, its students, and a third party, in this case, for example, the bank, we also have to bear in mind that this is more or less a contractual engagement, okay? And therefore, the terms of that engagement insofar as the sharing and protection of any data exchange is concerned would more or less be determined by the type of agreement or the agreement that is reached amongst the parties involved, okay? So a key thing to note is that there is likely, and indeed there is an overlap between trying to ensure that you're protecting personal data and taking into consideration the issues of confidentiality of this data. And it's likely that by taking care of one, you are indeed meeting the requirements of the other. So by saying that, I'm saying that, for example, if you comply with the requirements of protecting personal data, in this case, for example, ensuring that the data, you protect the privacy of the data subject, you ensure that you have you have obtained the consent of the data subject before doing anything with the data, etc., you'll more or less be complying with the requirements to maintain the confidentiality of that data. So I think those are some of the dynamics involved and that you would have to bear in mind when trying to grapple with the issue that you have mentioned.
Yes, but we are just talking about personal data. What about institutional data? Which could also, personal data could be a component of that institutional data. And I'm looking at, I'm thinking the main reason why a bank or a telco would want you to sign this non-disclosure agreement would be because of trade secrets, financial information. So is that not data that needs to be protected? Because I'm only hearing about personal data.
Yes, and Helen, there's a reason for that. When
yes.
Felix was talking about the definition of the data subject, he explicitly excluded the corporate entity from being a data subject, so that the way in which it's defined in the Act, it relates to a natural and identifiable person. So specific to the question you've raised, and let's use that example. You have USIU, USIU looking to facilitate access of a student into a banking or a financial institution or a telco. Two levels of protection. USIU and that entity might want to protect a situation where maybe the student goes in, there's a slight hiccup or a hitch when it comes to maybe the student going to the bank, let's say Bank A, taking information from Bank A and giving it to a competitor of Bank A, so Bank B gets the information. Let's say it could be a market analysis that has been done on consumer uptake of digital lending, something along those lines. Now that is market advantage. Those are the trade secrets that you're talking about, right? Now that is distinct from a student going in, being allowed access to data about Helen, Salome, George, all of us, which they then take and perhaps now put in the hands of a third party who is able to misuse that data. And I think that's a critical distinction. So a non-disclosure agreement might protect, so in terms of the claim of an indemnity, and these claims of indemnity usually touch on financial loss, for example. That will be a USIU and bank issue. But the data subject issue, now for instance, if I find out that a student of USIU went into a facility where I'm directly affected or can be identified, and I then ask that institution, how did this happen? And it turns out it was a student. You see, I will hold that institution responsible, because the question would be, did you take enough measures to ensure that my data would not be used for purposes other than that which I intended, right? So I, as the data subject who might be affected or embarrassed by some detail coming out about me, whether it's my health status, perhaps some personal troubles, some indebtedness that I'm having, all those issues that might bring down how perhaps the perception of society of me or my society of me, those are then things that I will raise with the institution charged with retention of my data and its protection. Now, the individuals behind it and their culpability, that becomes another level of responsibility and culpability, because all institutions are run by people. But the ultimate expectation under the law is for the institution to take measures to ensure that that data leak or that data misuse or abuse does not occur. Yeah?
Okay. Okay.
Yeah.
I'm hearing you about the personal data, but
Yes.
I want to know, so how is this institutional data protected under the law?
Oh, but that is not under the Data Protection Act.
Yeah.
Now, yes, so institutional data will not fall under the Data Protection Act, because the Data Protection Act has limited the remit of protection. So to be quite clear, there are other laws that protect from this kind of breach. Maybe let me start with the apex. So we have our constitutional law, which allows all parties, and this is irrespective of whether they are natural persons, that is you and me, or corporate entities. So under the Constitution, when you look at the right to privacy, and there was a case, the Nairobi Law Monthly, I believe, was involved in litigation about this, whether one is a citizen and the rights that then accrue. So you will find that under the laws that we have, not the Data Protection Act specifically, these protections are accorded. So you cannot wrongfully deal with institutional information in a manner that's not expected. So we have laws on defamation, we have laws on interference with commercial activity, we have laws that will provide safeguards to institutions where people purport to interfere with the privacy and the rights that they're accorded in order to operate in the market.
Okay,
yeah?
Thank you. I just wanted us to be clear on that there is still a safeguard for institutional data. Okay.
Correct.
Now, there was the second part of the question where George was to come in, the distinction. Is there really a distinction between data protection and data privacy? Or can the two terms be used interchangeably?
Thank you, Ellen. If I may come in, hopefully you are hearing me well.
Yes, we are.
I think it's very, very important for us to look at it on the risk part of it, of what we are all faced of. Let me start with saying that if you are all alert, and I know we and the listeners are, is that Safaricom had what was actually sued when two of the staff actually sold the data. And that is in our premises, is something that we are aware. And it wasn't a long time ago where the data was, some employee got the data and this data were able to be distributed to a few people for the reason that we know that that data is money and data can be used on very many businesses. And I remember on this class suit where 11.5 Kenyans actually sued through a lawyer X, which I will not want to mention, but you can refer to the cases all over. Safaricom was actually told that they were culpable for the employee having sold the data for some people to do some businesses. And therefore, it is very, very dangerous, and we have to be very, very careful as organization that the data that comes on our hands that belong to individual or the corporate must be taken care of with all the care that it deserves so that it does not expose the organization to some breach of data, which may affect you financially. And therefore, if you look at that case that we've looked at, is that we do not know where it's going to end up, but we know some judgment were also passed on a few, and I think the two culprits were able to face some induction. They were able to be, actually, the court found them culpable. So what then the data protection? We are simply saying it is not really only for individual, as our perspective and the risk and the insurance part of it, and I will want to talk to that area, is that we believe that the data protection is also important in terms of the organization protecting themselves, because if you do not do that, you will expose actually your both corporate information and the individuals that are involved. So the degree of care that are required is for us also to get very, very keen as major organization on how do we handle data in order to take the interest of not only the corporate colleague, who in this case are called the clients, and also the personal, both corporate and personal client that you would have. So Helen, I would say with good clarity that the risk exposure is for both, and every person has to be very, very careful on how they handle my individual and my corporate data.
Thank you. Thank you. Kananu and Felix, is there a distinction, or should I just drop that line? Is there a distinction between data protection and data privacy? Can they be used interchangeably? You know?
Yes. So, I mean, I think we'll be splitting hairs if we try to sort of identify the distinction between the two, although they all are sort of related to each other. So I guess data protection is, broadly speaking, speaks to the realm of that deals with the protection, with the mechanisms that you put in place to ensure that the personal data you are handling is handled in accordance with what the law requires, and that you do not abuse the rights of the data subject. So data privacy is perhaps actually a subset of you know, those mechanisms that you put in place to ensure that you protect personal data. In fact, what the Data Protection Act does is that it sets out a number of principles to guide persons who process personal data in how they then process that personal data. And one of the principles requires the data controller and/or the data processor to ensure that the manner in which they process the data ensures that the privacy of the data subject is protected or is upheld. Yeah. So, and that's why you then, that's where you come, you know, the idea behind perhaps encrypting the data, anonymizing, and, you know, pseudonymization of the data that you're handling and the data subject comes into play. But of course, depending on the context in which you are processing the data.
Okay, thank you. Kananu, there is something you said that has stirred up a question here. Raymond Musumba says contact information of Kenyans is heavily abused, for example, by companies that possibly buy data and send spam marketing SMS. Since phone numbers can expose so much related personal data, how does the Data Protection Act address situations like that? Thank you, Raymond, for that question. Kananu or Felix?
Thank you, Helen and Raymond. That's a good question. Again, just Raymond, awareness of the data subject, of the fact that, and perhaps maybe I should even say citizens or us, awareness by us as data subjects of our rights is very important, because it's only once you know your rights that you can then know what to do about it. Okay, so I'll say this, Helen, just walking back a little bit maybe to the question you'd even asked before. You see, under the Constitution, which is the law that I'd mentioned before, every Kenyan has a right. In fact, it says every person, you have a right to privacy, which includes the right to have information relating to your family and private affairs, not unnecessarily required or revealed. So if you know that that is a right, and again, what the Data Protection Act has done is to break that down further. Given that you have that as a right, what it means is that for every right, there's a corresponding obligation by somebody to do or not do something. And if they do not do that thing that they're required, you then have a right to claim for compensation or remedy for that wrong that they have done. So the protections that are then given in the Act are that you can then claim for financial loss when these companies are selling your data in order to market. You know, I have often queried how I receive on my phone messages about loans that I should take from different, loan sharks and things. And I'm sure I'm not the only Kenyan who gets these messages, but the thing is, we don't do anything about it. I mean, we might, we let them get away with it. So if we then understood that we have a right not to have our information used or abused in that way, then we can take actions to claim financially. We can then take actions to require that they stop this misuse of our information. The reality for most people is that there's a disincentive from taking court action or asserting rights, because many people perceive it as quite an elaborate process. It's a process filled with delay, but there are certain actions, such as in the way of injunctions, which are stop orders that one can take that don't take too long to obtain in order to safeguard, especially if there's a real and immediate risk that your information or data will be continually abused to your detriment. So yes, there are safeguards and there are steps that one can take to safeguard themselves, and the law does provide measures of protection around this. I don't know if Felix would like to add something on that.
Yes, certainly. And I think this is one of the contemporary issues. So yes, I think it's the issue of use of contact information and details of in respect of a person is one of the key issues that that most people are grappling with at the moment. So what the Act does, it sets out the broad framework, sets out the legislative approach, but then we have subsidiary legislation under it. So we have the data protection. We have 3 sets of regulations that have been proposed to be enacted under the Data Protection Act. One of these regulations is the Data Protection General Regulations. These were published sometime in April this year, and they are currently going through the motions of being passed as subsidiary legislation. And this particular set of regulations does actually speak to the question that Raymond has asked. So what it does is sets out a couple of guidelines around how that issue should be dealt with, and I'll just mention a couple of them. So the first one is, to begin with, it outlines the use of sensitive personal data for commercial purposes. And I think I don't know if we defined what sensitive personal data is, but just to recap, this is a category of data that the Act requires be handled with extra care because of the risk that any mishandling poses to the owner of this particular personal data. So an example of this is any medical or health related data relating to the data subject, amongst other types of data. So you are absolutely not allowed to use that data for commercial purposes. Now, other safeguards that a data controller and the data processor is required to comply with include the requirement that you must, before using that personal data, for example, to send a promotional message to someone on through text or through their email address, is that you must obtain their consent. And even before that, you must have actually obtained that particular contact information from the data subjects themselves directly. Okay. So if you obtained their data from a third party, and that data subject had not consented to that third party sharing that their contact details with you, then you cannot go ahead to email them or write to them in any way. The other safeguard is you are required to notify the data subject that, and this is prior to using this data, you are required to notify them that you're actually going to use this data for commercial purposes. Okay, so you probably need to tell them, okay, I'm going to share this information with X, Y, Z for X, Y, Z reasons. And I think lastly, you need to always provide the data subject with an opportunity to, and I think Kananu touched on this, to opt out of, you know, of any means of communication between you and them, and that needs to be very conspicuous and very explicit at the point in time when you're getting their contact details.
Okay, thank you. You've talked about consent, and I have a whole like maybe 20 minutes. I want us to just talk about that informed consent at some point, because there's a part of me that feels that consent is kind of like illusory. And when you look at an organization trying to get you to do something so that they are able to achieve an objective, and yet they still require informed consent from you, you know, so we'll get into that. I don't want to get into that right now. I just thought to add that I think the Consumer Protection Act also speaks to what Raymond was asking about, right? And then who's going to educate all these entities on this information? Because just go to, I know Safaricom has tried to, they're saying they're going to implement something that, you know, will make it impossible for merchants to see our mobile numbers like banks do when they are sending us like our statements. But I don't know about the rest, the NIVASes, and is that going to cure it all? You know, I don't know, but it's I find it to be like harassment, you know, on my phone all the time. Somebody sending me a text, and then I remember that I shopped there and I paid by M-Pesa. Okay, so there is a question by Wilfred Kidula. A data controller can be the data processor, as you have discussed. What happens if you are the data processor and discover you are the data subject? Wilfred Kidula is our librarian here at USIU.
I mean, I guess it depends from which position you're operating from. So you could be both. I think it would be difficult. It wouldn't be possible for you to achieve both identities at the same time. I think what you have just mentioned is that a data subject is a natural person, and a data processor is any other person that then you know, receives instructions from a data controller on how the personal data will be processed. So it is quite possible that you could be, you know, you could be processing data as a data processor that perhaps I'm imagining, going by the question, that includes personal data relating to yourself. Yeah, I don't know whether that's the situation. Perhaps you should provide more details as to what exactly he's trying to address with the question, and maybe with that context, we can provide a better response.
Yes, but from what you said, Helen, it sounds to me like you're dealing with a situation where he's an employee of USIU, and then perhaps is the same person processing or required to process the data. Am I right?
Yes, I'll answer on behalf of Wilfred.
So you see, there's such a thing as distinguishing, in my opinion, the roles that one is performing. So when that data is being processed by an individual, it is being processed for the organization, right? So the organization remains principally the processor, but it is doing it through the person.
The individual.
Precisely. So there is then that distinction where, as Felix says, you're not going to have both roles at the same time. You understand? So you will be facilitating it for the processor, and as you're processing other people's data, yours is part of that data. So hopefully then your threshold of security is so much higher.
Yeah, and I know why Wilfred is asking that question, and it leads back to the pre-briefing, the briefing we had before the webinar. So your USIU, you have to process data to give to a regulator. In this case, the Commission for University Education. So you will find that you're sitting at your desk as maybe Wilfred, and as I said before, John was in admissions. So as John, and part of his data forms this information that will, or comprises the information that will go to the Commission for University Education. So I see where he's coming from. Yeah, in that context. Yeah.
Information.
But I guess in any event, the reference point is the requirement to basically ensure that you're in processing the data, you are adhering to the principles that the Act prescribes for processing data, and you uphold all the rights of the data subject, yourself included.
Yes.
So I guess that's the point to always bear in mind.
Okay, thank you. And so we have a comment here from Dr. Lola Odubeku. She's on our council. Thank you, Lola, for attending. I just want to mention that our Chancellor is also in this webinar, Dr. Manu Chandaria. Thank you. So we have, she says that sensitive personal data, no, that's not the one. She was commenting on data privacy, the difference. Data privacy relates to who has access to the data, whereas data protection refers to the tools and policies used to restrict access to data. And she ends by saying a subtle difference, easy to confuse and incorrectly used interchangeably. Then there is a comment here from Emmanuel. I see a hand raised. Can you ask your question in the chat, please? Is that Michael? Michael Njuguna, could you please type your question in the Q&A? Thank you. There is, I don't know whether it's still from Lola, but somebody talks about sensitive personal data means data revealing the natural person's race, health status, ethnic, social origin, conscience, belief, genetic data, biometric data, property details, marital status, family details, including names of the person's children, parents, spouse or spouse's sex, or the sexual orientation of the data subject. Then there is a comment from John. We demand so much in terms of data protection and privacy from organizations, yet we, the consumers, are the biggest culprits. For instance, we break this data protection rule when we share video of persons caught in funny instances on Zoom, making them viral. But did the individual consent to such? And how can the individual seek redress? There we go. There's a question right in there. Who wants to take that question? Kananu? Felix?
Yeah. So I think when you look at the regulation, I think they speak to that question. And I guess even the Data Protection Act itself anyway. So remember, we start with the principle that you need to protect the privacy of a data subject, okay? Among other safeguards that you need to bear in mind when you're handling any personal data. Also remember the right that a data subject has over their personal data that you are handling. But there is the exceptional cases. So I'm assuming that in this case, if the video, this funny video is already public anyway, I don't think the act would, the safeguard would apply because it's already public. Whether in instances, whether it's become public through your own publication or through some legal means, or the publication is grounded in something, in some lawful, on some lawful basis. So in that case, we would need to look at the particular instance itself to determine whether there is any breach of a data subject rights when we republish the already public information that they have published about themselves.
Yeah, I think here he was looking at, so what would be the remedy? So let's say I didn't give my consent, and we've seen people, pursuing civil actions, defamation of character, you circulated something, invasion of my right to privacy, it was just the two of us who are there, but you've gone and sent it to everybody. And we've seen people actually getting a compensation. I think there was a former Miss Kenya who got compensation when a video, an intimate video she had done with her then partner was released by the said partner. Yeah.
Yeah, you're exactly right.
Yeah.
And maybe I can add a comment.
Yes.
Maybe I can throw in a quick comment. So of course, it doesn't matter that you have publicized your funny video already. You still retain your right over that particular personal data that you have put out, and you can ask of a particular person that you can identify to, for example, either pull down that particular video or content if it's been, for example, altered or manipulated in a manner that makes it different from what was already published. You can ask them to correct, okay? You can actually even object to them continuing to put it up anyway. I guess it goes back to the issue of you basically withdrawing your consent, to the matter, to the video remaining public. So you still retain all your rights as a data subject.
Okay, thank you. I don't want us to forget one of the key things about this webinar today, which is also risk imperatives. I know we can all put in place all sorts of mitigation measures, but there'll still be a data breach. And so I want George to come in, in this segment and talk to us about, mitigating that risk from an insurance perspective. because I know you'll talk about the kinds of things that organizations need to do, including formulating data protection policies. But we know that something will happen at some point, and then they will descend on you. So what do you do? How do you need to make sure that you are protected and that risk is covered? Things that, boards of directors and executive teams need to consider as they sit at those decision-making tables. So George, over to you.
Thank you, Ellen. Thank you very much, my colleagues in the legal part. I think they've actually laid a very good ground for us now to go through. We say the risk, guys, and especially the law is the first defense. But then you will now have the insurance that come in on the second defense level. That what if those things happen? What then do we do? Do we have a recourse? Do we have where we can actually get this apart from going to the court? And I want to say that in the insurance industry, we come in as the second line of defense, apart from the first line of defense of you having your own data protection officers, a legal person or anybody who is educated on that area, will ensure that your data and everything is protected, the IT team and every person. But what if those things are breached? Then we come in. Yes. We come in as the second line of defense in terms of the insurance packages and the risk mitigation factors that we'll bring in. And one of the insurance package that have been done all over the world that started in Europe and now is in Africa and the other part of the world is the cybercrime policy that comes in that is able to take care and mitigate of some of those factors. And the cybercrime is basically insurance to protect you from loss or liability and or damage against major internet-based risks, risk related to information technology, IT, infrastructure, and even what we call the cyber attack that some majority of us have thought about and heard about. And what is cyber attack? It's simply a digital attack designed to disrupt your access to or the operation of your computer system. And therefore we have these hackers, we have people that comes in, we have people who sell data, we have people that bring those things that eventually will be able to stabilize your system. And in this, us as an insurance company, we are able to take care of a few things that our legal colleagues have brought in. Data breach, for instance. What if somebody breached my corporate and individual data? And what is then the breach? So if we define on our perspective what's a data breach, it's not very far from the Data Protection Act. This is the unauthorized acquisition, access, use, or disclosure of any, or the loss or the theft of personal or data or confidential corporate information by the third parties, which in this case might be the hackers, might be anybody who is just disseminating this information, like the two staff of Safaricom that were caught on this thing. And we're simply saying if this thing happened, and therefore you as organization or as a person who was the source of data is actually sued or taken to court, then we'll be able to pay you for that breach of data cost when you are found to be culpable. And we will take care of the legal costs of investigation of the breach. We take care of any documentation we'll be preparing for the regulator, because one of the things that we've seen when that breach comes and you are a bank or you are any a regulated entity, then you'll be required to give a lot of information to your regulator. So we take care of those costs plus even forensic investigation and the cost of stopping that breach not to happen again. And therefore, we help both individual and corporate organization to be able to do that. On our cyber or data breach cyber liability cover, we also take care of what we call the malware attack, which is normally any intentional crafted intervention to damage your computer, steal your server, all your client information in order to intrude on your data. And when they intrude in, they'll be able to take this data and sell it outside. And when they send the malware, it's able to affect and disjoint your data sometime, and you do not know what to do. And then that is really interrelated or related to what they call the cyber ransom losses. More often than not, when they've done this, and if you remember the case 2 years ago, there's two gentlemen actually attacked the banks, and they actually said, pay us X amount of money in order to release your data. And I don't want to mention the banks for the privacy issues, but all of us who are some of these facts were on the public domain. And therefore they say, we will only give you this data, or we'll only give you the information we've taken from your client after you've paid us X amount of money. And therefore, we come in and we're able to negotiate, we get you guys to negotiate with them, and the cost of that, sometime even the ransom amount is actually payable. What about when you have attack? We also need to have what is called the data recovery costs. And it's a lot of work that your IT will be able to do to reconstruct some of the damaged data in the system. And therefore we come in and we're able to say, what then do we do to be able to compensate you to get somebody with another ethical hacker? We call it now ethical hackers that will come in, ethically hacked in, see what has done, and be able to restore some of your data which were destroyed with these people. But the major thing that we fear is that when the cybercrime or the data is exposed, we have something which is called reputational risks that organization goes through. Having exposed your client data, for instance, if you go back to the banks and even the Safaricom, and we will want to say that this apply to every industry, even the university, USIU. What if we expose all the grades of all the students in ICU? And this is what the hackers will do. They'll come in, attack your system, have all the data, and say, everybody got this grade. And if you do not really pay us, we'll do X. So this becomes what we call the reputational risks. And therefore, the cybercrime or the insurance that we give will be able to pay you the costs of the PR costs that you'll go through in order to manage that cost. So cost of reputation that you may have incur, and you may have to go to advertise, you may have to get some PR guys intervening, you may have to actually look for some people who know these people and tell them, don't do this, and that cost is actually also covered. On the personal, we've seen where your email is even attacked and destroyed, or somebody tells you, if you do not give us X, we will actually expose all this data, as Felix was saying, and my colleague in the legal, and they say, we will expose you, and we'll be able to say, this is what you've done. And we are simply saying in that, so they're able to probably share compromising information about you, which are very, very sensitive to your personal or organization. We look at it and we're simply saying, when these people came in, how did they get the data? And when they got the data, what are they using for it? And if you have this insurance cover, we'll be able to say, fine, some of those intervention, probably the cost of you reactivating your account, doing everything, or the exposure, which we are simply saying the residual risk that has gone out, we also come in and pay for that on case by case when we look at what did happen. And then one of the area that is very, very important that they use with this data is the credit, your credit card or credit information, the financial information. We've seen actually the hacker comes in, and for the financial institution, when they go in, they can hack in and actually transfer the money out of your account. And therefore you lose your finances. We've seen credit card being used because somebody has your data and information, which we are calling scamming of some of that data. And therefore you have a financial loss that is related to that. And that also comes in. For organizations as USIU and the rest, you'll be sued for the breach of data, confidential data. Where do you get the recourse? If we realize that you did not expose yourself, but the data was breached, then we also ensure that you have some legal costs or auxiliary related costs paid for you when you are actually sued for the data breach. So that is also the legal defense cost, the fines, the legal defense cost that you are given a legal person to be able to defend the organization or the individual, and those costs come in. But apart from that, we've also seen where you have what is called the media liability. And the cybercrime will be able to look at it if that information comes in and leak out to the media and is spread so fast and damages even your business income. And that has happened. That one information can be part of what you did, or the customer who was not well treated, and the customer goes to the social media, the newspaper picks it up, and is all over the world at a click of a button. And that cause can actually impact on the losses that you may incur that year, because people will say, why do I trade with such organization? Here home, we've all know about the Kakusi case. And some of those who went to the media and went everywhere, and we know the repercussions of those. And therefore, that cost that you'll be able to incur, they call consequential costs, which are loss of income. We can also mitigate some of those. So I just want to mention those a few. So we are simply saying there are covers that we have outside there that will help you even when they hack in and destroy your software, that will be able to give you the cost of replacing that software when the data has been breached and you have incurred some losses. So we are saying, apart from loss of income, you have legal liability part of it, that you may have a reputational risk also, or the legal defense cost of the losses that we incur. You may actually may have to have lost some money through use of your data, especially, and things like the credit card. And basically the insurance company comes in and give you some compensation for that. But the last and most important, we've had regulatory action taken against you. That the data commissioner in Kenya may actually sue a company who actually decides to be reckless, or inadvertently is reckless and the data of the client is lost. You maybe have sanctions in terms of fines and everything. And so long as you do your best and that happens, then this insurance will also come in and mitigate some of those covers, those losses that you may incur in the event of a regulator finds you that you did not handle your data and the breach correctly. I will then pause there and probably we proceed, and then we'll be able to look at what then is not covered. What do we don't take as insurance company despite of those risks being to you. Well, lastly, we encourage all the organizations that have now with this law, have a data protection officer employed in your firm who will be able to ensure that you are there to laws and the requirement. And this data officer, protection officer, should be in tandem with IT and your legal team, able to ensure that the client data, your own data, or any other third-party data is protected legally. Thank you.
Thank you, George. In the course of your brief right now, you've actually veered into, okay, I don't know whether to call it, did I hear you say that if there is information out there that about the institution and you suffer like financial loss, this would be, this cyber crime policy would be able to compensate you as an organization?
Yes, Helen, that's very, very correct. That when you take this cover, we protect you the reputational risks outside there, or the legal costs that you may incur will actually be reimbursed to you, and they are pre-agreed at the beginning when you take the cover. Now, what is my legal exposure?
Let me stop you right there. So when you say, because I'm looking at the media liability you talked about. So
yes,
only if we are to file suit against that person would the issue of compensation come in, or if we have information circulating or that has circulated about, let's say, the university, and we can be able to compute the loss that we have incurred, do we necessarily have to file a suit against the so-called purveyors of that? Because most of it can be false information, you know. Do we have recourse, or is it only after we have filed, say, a case for defamation and got an award that we then come to the insurance company? I need to understand that.
There are two things. I think Ellen, you're bringing to aspect. That is what we say, that because of data breach, I've lost income.
Yes.
And therefore, the data breach may come through the media or may come through the cyber attack. On the cyber attack, it's very, very easy for you to know that when my computers were down in the university, it took us 7 days, and within 7 days, we lost XY man hours, and we don't really need to wait for the court. It's direct. Now, look at what we call the defamation, that basically the things have gone to the media, and therefore people refuse to buy some of your products. Assume that it was false information in case of Kakusi, for instance, that basically what they did, they never did it. But how much did they lose in that process? How many people canceled? There were supermarkets in UK that canceled the order. Again, in that case, you really don't need to wait for the suit to come in, because you know the financial implication already lost in that process. And therefore, we simply saying, two supermarkets cancel the order. What was the order for the last 2 years or 1 year? What is your average losses that you have within that month? It's compensated.
Okay. Thank you. Kananu and Felix, do you have anything you'd like to add before I go to the question? There's a question on Facebook.
Yes, Helen, as you do that, I actually wanted to get George back into the conversation, touching on something that would be a prerequisite before one takes the cover. George, are you able to speak to any audits that you would need to do to ensure that there's some form of criteria that the insured will have met? So, for example, there are the principles which any entity is expected to keep to when it's keeping data. So some of these principles are accuracy of the data, safe storage, the integrity and confidentiality of that data, accountability to the data subject, utilization for limited purposes, and of course, lawful, fair, and transparent use of this information. So prior to insurance, in the way that, of course, we understand the contracts to be those of utmost good faith, will the insurance companies require demonstration by the insured of these, that they have met these criteria?
Thank you so much, Kanano. That's a very good question. And that's what we needed now to find out. And you've actually jumped the gun, but for the good reason, to lead me through this. So basically, the insurance company will require you, first of all, to be able to ensure that you are there to the law. So we will not really be jumping in when you know you inadvertently don't care about the data, you throw them everywhere. And that's why we'll be able to insist, who is the custodian of this data? Who is your data manager, officer, and who and how do they keep this data? But always we are driven towards the legal requirement, the minimum legal requirement standards that are required for you to keep that data. If that data is kept then correctly, then in that case, we'll be having amenity to cover you. The second thing that will require is, what is your system and the processes, your computer networks? Are they outdated? And one of the things that we don't cover is if that system is outdated, is no longer being serviced with your vendor currently, or it is weak, that you've not taken all the safeguards that are related to the requirement of the IT, for instance, or the data, the regulations and the law in the country. So you must adhere to those first for us to come in, because we only come in for those accidental that you've done your best for it to happen. We also do not cover, if anything, those data are lost by the shareholders and the owners. So we are simply saying, if you are the owner of the business and you are careless about it, then how do we do it for you as a director? However, we cover for the staff, because we are simply saying the staff can be malicious and release malware in your system, or trigger a cyber attack in conjunction with the people outside, exactly in the case of the Safaricom staff. So those are coverable. So what we will require of you, the prerequisite that will come and we do risk mitigation factor, is to see what is your IT system, how is your data record is being kept, who is responsible, are you adhering to the law, what about the checks and balances that are put in place with your risk department. Remember, insurance is a second line, not a first line. So yes, there'll be prerequisite side things that are required to be done, the controls and checks and the balances that you need to do. And we carry you through that. We're able to audit your IT system and tell you, this may be the weakness, this may be the strength, and then what do you do? And that is done.
Thank you. So definitely, there are some boxes that you need to tick.
Yes.
So it's not just automatic that, yes, they'll compensate you from an insurance perspective. And this takes.
But just to add, Ellen,
yes.
Assume that you take it for the things like the reputational risks of the company. So long as you are not reckless, really, we simply believe that information went out or somebody said something that affected the company, which was not under your control. So they will look at the policy in case by case. What is the effect and what are the issues? And therefore, case by case, we look at it. And sometimes some of the things that comes, we've seen the claims coming which were not anticipated at the beginning, but it's still coverable because it's within the purview of the policy wording.
Okay, thank you. I want us to take the next couple of minutes because I see it's 3:22 p.m., meaning we have like maybe 28 more minutes to talk about consent, data privacy or data protection and consent. And specifically, the role that consent plays in data protection and privacy. And as I kick off this discussion, I just want to put this out there that there was a survey that was conducted where it was said that 50 trillion personal data transactions a year are conducted by a company you don't know. And we know that when, let's say I want to update software on my phone, there will be a pop-up that tells me, this is a privacy policy, and there are those boxes where you have to like tick. We know we don't read those things. How many people read those things? Kananu, do you read the privacy policy? Yeah, so while I know that as an individual, I have control over information that concerns me as a person, and that the law right now in Kenya gives me as an individual the right to consent about uses of that data, particularly that is collected online. It's this calling consent thing that for me I find to be a bit illusory, and I'll give an example. Say I apply for a job at some organization, and part of their recruitment procedure is that I must be subjected to a medical exam. And so, you know, you've done all the negotiations to the point where now you're waiting for an offer letter, and then they spring that on you. What do you think as a potential employee you would do? You would simply jump at that opportunity to do the medical exam and get the job. But if you're feeling uncomfortable about that whole process and you question it, you know very well they might actually drop you. So I want us to talk about consent because I feel that in some instances, consent is entirely, like I said, illusory. You know, so what is the role of this consent in data protection and privacy? Thanks.
Okay. Thank you, Helen. And please, George, I hope you're also going to join us in this because you are a data subject. and I think it will be interesting to hear your perspective on the risk mitigation component. So I think a couple of things, and I'll use as a reference point the GDPR. After the GDPR was introduced, or when most companies in the EU were aware that this legislation was going to be passed, what many people, including people in this part of the world, began seeing is that there were many emails coming to your inbox saying, you know, from newsletters or magazines or other types of things that you might have previously subscribed to or expected as a matter of course. They would ask, if you recall, there was a question there about, do you still want to be retained on our mailing list and so forth. So there were specific questions that were asked. And I suspect many of us just ticked the box to continue receiving this information. The reality is, as Helen has said, many of us, lawyers included, if you don't have to read the information, you presume a couple of things about that information. And what I want to say about the way the GDPR approached this and required businesses to approach this is to make sure that the questions being asked of consumers or customers were simple, direct, and in a sense, providing that the understanding and therefore allowing for informed consent. Now, to contextualize this conversation on consent, what would happen if you didn't give consent? Now, to that risk component, which is what George has said that they would ensure. Usually, if your rights have been violated, you'll be claiming a couple of things or alleging certain things. So, for example, you might allege that you have suffered financial loss or that you have been distressed in some way or other. You might also suggest that your identity has been stolen or that there's damage to your reputation. Some people will say that there's loss of confidentiality of data or loss of control over that data, or discrimination arising from, you know, some information about you being known. The reality is, when these claims are presented, they're not presented without context. Now, that business or entity that then asks you whether you accept the cookies or whether you want to be retained on the mailing list, they will come in when you accuse them of all these things causing you financial loss, distress, discrimination, and so forth, or even that employer who might have required you to undergo some medical test, and perhaps because at that point maybe your claim will be misuse or mishandling of that data. Their defense will be that you signed off on a document that stated specific things. And this is why it's important to understand that while as a consumer, you might be making some of these decisions on the fly, as it were. So you're downloading an app while you're perhaps waiting on something else to happen, and therefore you're not taking the time to read this information. That of its own will not be justification when the business presents the position to a neutral arbiter to state that they did what they needed to do and what the law required them to do. So as you can see, there's an expectation on two sides that the businesses will inform you of what they intend to use your data for. Now, it is upon you, therefore, to understand what they're telling you that they will use that data for. There's a word that George used, which is very important whenever we are discussing anything that touches on the law: exclusions. You have to understand what the exclusions are. So sometimes you will say that, for example, when it comes to research purposes or people submitting your information to a regulator, then they'll say, of course, we will use your information for commercial purposes. But then if we're required by a regulator to submit your information, we will do so. And for that, you will not hold us responsible for what they end up doing with that information. So there's an expectation, and for Kenya, unfortunately, we are not yet that sophisticated in terms of there being knowledge among the masses and deliberate reading of the information that's put in front of them, but we need to get to that level, because it's only when we get there that, Helen, to the point about the implementation or the demand that these requests for consent are made more relatable, that perhaps we will begin to see. In Kenya, we are not very big on collective actions. That's, lawsuits by many people at one go. What we see a lot of is representative actions. So where one person sues on behalf of many. So I think if we see this happen, these actions being brought, where people are saying we are not happy with how supermarket X or bank B, we need to, if those steps are not taken, believe me, there'll be no or little evolution of the law other than the copying or mimicking of what happens in Europe. That's my take on the consent component. I don't know if Felix or George, maybe George, you'd like to add a comment on this?
Yes, I will add something. And I think one of the things that you say rightly, that what we look at, we call it the privacy liability. That's the word we will use on our technical term on the risk. So in your privacy liability, we will look at that in the consent. Were you made aware? Are they reasonable? Are they within the law? Remember, for the employee, for instance, we'll go to the Employment Act and we say, does it allow you to do this? Very interesting case that happened that I handle in my early career is whereby people were excluding the people who had HIV. And it was so bad that it was actually the courts of law say that it's discrimination. And as a result, as insurance company or anybody, you cannot discriminate about that. And therefore, we have to be very, very careful on the consent. What do I consent to? And what should I not do? And this is where you now know your legal right. And you say, for instance, if I've been told to go for medical tests, there are two cases. In Kenya today, you cannot discriminate, and in the world today, discriminate against somebody because of HIV status. So you are allowed to employ them, give them everything, and therefore you cannot use that. And therefore we look at the law, we look at the trends in the world, what is reasonable. But I really hesitate to say that majority of us would come in and probably just say yes on what you see in your TV comes in and pop up and saying, agree to this, your phone come. And we want to encourage you as insurance people, we ask you read and understand, because some of them actually saying that they can utilize your personal data anywhere. And when we find out that you consented for them to utilize it, how then do you come to us to be able to pay you for financial loss or reputational loss when you consented to that? And therefore we advise you, before you do that, do you uphold your rights and also contact your legal person or the insurance person to say, yeah, you can't sign that, because if you can't sign that, it weakens your compensation. So be very, very careful with the privacy liability and ensure that you protect the private people or yourself and also the organization through ensuring that I do not say yes or no for the things that I do not understand.
Are we then saying that in a way, by me consenting, I'm like shifting? I'm just looking at the notes I was writing as you are responding. I'm shifting that it's like it has consent has this legal effect of shifting the liability from the data processor to me, the data subject. So I need to be very careful that even as I read those lengthy, sometimes complex and barely comprehensible policies, privacy policies that I'm sure before I tick that box that says, I agree. I think that's what I'm hearing. That's the burden now shifts to me as the data subject. And yeah, and it's no longer a burden on the data processor. They'll have discharged that obligation.
That is correct, Helen. But I think on my part, I'll still want to emphasize this. You see, the expectation always is that the person asking you to consent will have reduced or made it simple. Let me put it that way, quite simply, that they'll have made it simple for you to know what exactly you're signing up for, okay. Right? Now, I think the slight conflict that exists, and I do wonder actually how the insurance sector would look on this, if, for instance, there's a challenge or a contestation about the complexity of the way in which that information was put in front of you, so that, as I said before, and in the EU, the businesses were required to make it simple, so that you're not then having legalese and too many words or terms that you don't understand as a consumer. It needed to be that you read and you knew. They're going to use my address for sending me, promotional material. They're going to send me something in the mailbox. So you knew, and you could understand and say, yes, no, I want it or I don't want it. Now, if they then make it complex and prolix or too long, then I think what I'm waiting to see, and I think even in the EU, they say that they're waiting to see the flurry of litigation that might come up, questioning the adaptability or usability of some of these T's and C's, right? So that then we perhaps will come to a point where these are one-line sentences instead of paragraphs like, Apple does. Apple sends you paragraph upon paragraph to accept, yeah? Okay. But it does, once you say yes.
Yeah, I think you are very right on that. What we normally look at, and when we advise our client, is that there is what is called the Consumer Protection Act, which is very, very important. And we tell them, whatever you do to the clients, those are the adhering to the law requirements that we want you to do. And we encourage them information to be very, very simple, that anybody on the street will be able to understand it, and the legal colleague will tell you that we assume that client that you're interacting in, you give him such information that anybody on the street will be able to understand when they're explained to or when they're written to. And therefore, the duty becomes on you as the client who is giving the information to be able to communicate on a simple term or legal requirement. But you will realize that each jurisdiction will actually put different standards. And some of these standards are actually put with the regulators of those jurisdictions. And they will tell you as the owner of the business or the owner of the university that this is how you should be able to give in information to the third party. So long as you are there to those requirements, for us from the insurance part of view, we will say that's the law, that's the requirement that is required to be done. And we tend to agree with what is being agreed as a practice in every market. Each market will vary on how they handle it. But so long as that is agreed, and we say this is a legally agreed forum that you are required to disclose that information, then we will be able to pay for that. And we also look at the other person who is suing the client, that we say, was the knowledge given as per the required by the law? And therefore that we are saying that now we say the law become an us. So the law should be able to be put in such that it protects the consumer's rights or the weaker person's rights. And therefore that's what we'll be able to look at. But we also look at what are the trends? What are the reality in the market? And therefore we keep on adjusting our policy documents depending on the rigor and the reality in the market and what will be able to take care of the client so that you do not always leave them at the deep sea.
Okay, thank you. Now, there were three questions. So one was to do with So in partnership programs where all partners contribute to data, how can all of them have equal intellectual property over this common data? So we are now veering into IP on data. That's the first question. The second question is, somebody is wondering why or how the Data Protection Act would come into play in cases where public servants are required to declare their wealth, okay? And then the third question relates to, as I walk into even USIU, as I drive in or walk in, I'll be asked to leave some information with security at the gate. That includes my telephone number and all sorts of information. So this person is asking, Tony Korir on Facebook, in many instances, when entering certain buildings or shopping malls or estates, one is asked to provide their personal details like name, ID number, phone number, car number plate, etc. Is there a safeguard in place to protect the data left by people in those places against misuse, or the information getting to other persons not authorized to access such personal details? And I think this question was answered by Felix earlier on when he talked about how you process personal data and ensure the integrity of that personal data. So those are the three questions on the chat. If we could quickly go through those ones, because we have 19 minutes left, and there are 3 questions in the Q&A. One of them really was what we were going to conclude with, some of the strategies that organizations can employ to ensure data protection mechanisms are in place. So over to you. Thank you.
Thank you, Helen. I think I will take the question on wealth declaration, and Felix will address the question on IP in the partnership situation, and also the question that Tony, I think he'll just highlight 1 or 2 things about what Tony has asked. So on the wealth declaration, this is for civil servants. It's something that's expected of civil servants. I think it's important that we remember, even as we're talking of data protection, that there are other laws that continue to operate in parallel with this law. So when it comes to civil servants' wealth declaration, that is a requirement under another statute, that civil servants will declare their wealth. And we have to remember, again, I think it's useful to contextualize the why. This is actually under the Public Officers Ethics Act, that this is required. And then, of course, we have the Bribery Act that was introduced in 2017, all of which are geared towards ensuring that the income that one has is what is able to be mirrored in the assets that the individual has, such that then if there's a disparity, there can then be legitimate questions as to how certain wealth was acquired or assets were acquired. So these are all things, as you can see, there's a statutory or a legal basis as to why these requirements are then put in place. They are not simply to nosy about your business. So with that legislative framework being put in place, what it means is that there's then an expectation that the person or persons, and here I'm talking about the legal entities, to whom the information is being disclosed, there's an expectation that those entities will only use that information for a lawful purpose. They will use it in a fair and transparent way for the purpose intended, such that if there is a query about Helen's net worth, so on the assumption that Helen is a public official, and Helen, we need to interrogate 1 or 2 things about your lifestyle, then that is not going to be information spread to everybody. That will be information shared with regulatory agencies, for example, the Ethics and Anti-Corruption Agency. The Director of Public Prosecution might have that information, of course, if they're prosecuting you, or if you have put yourself up, and the most recent interviews that I can think of, we had the Chief Justice position that was up, and we also had the IEBC officials. So what you will notice is that whenever the people who are raising questions about asset or wealth, when those questions were being asked, the public was not informed of the content of the wealth declaration forms. Questions were posed which suppose knowledge between two people, the entity that received the information and the declarant, that is the person who submitted that information. So again, that is purely a regulatory thing, and there is a legitimate expectation by the person providing the information that that information should be safeguarded and simply used for the intended purpose and nothing more.
Thank you.
Yeah, thank you, Kananu. And I think perhaps I could just buttress the point you've made. So the personal data that you provide as part of providing, submitting a wealth declaration form is also covered or is protected by the provisions of the Data Protection Act. So the Act does specify certain instances where the safeguards will not apply to certain information. And this is the case of what the Act refers to as national security interest or public interest. And it sets out a very exhaustive and very narrow range of instances where the Data Protection Act would not apply. And the provision of wealth declaration forms does not fall within any of those categories. So I thought it's just important to throw that in. Yeah. So I think I'll respond to the question relating to the ownership or division of ownership of intellectual property in data. I think this is more of an intellectual property question, but I will address it nonetheless. So, and by saying that, I mean to say that the ownership proportion would really depend on the contractual agreement between the parties.
Yes.
And from a legal point of view, there is a mechanism of apportioning or determining how that the intellectual property right will be shared or owned. So I think that answers that question. So I'll move on to Tony Corrill's question, just very quickly about the safeguard over the personal data that we provide when we are accessing, public, buildings and the like. The key thing I should mention there is that the issue of consent comes up yet again. You need to make sure that the person knows that they have an opportunity to know that they're going to be providing this data to you, and they have an opportunity to decline to provide it to you. So as the collector of the data, you need to adhere to certain requirements, and I think I touched on those. But I think some of the things that would be key to repeat would be, for example, you should only collect that type, that data that is relevant, for the purposes of admitting the person to the building. You should ensure that once you collect it, you store it and process it securely. And even in collecting and processing it, you only use it for the specific purpose for which you collected the data from the person. In the case of, if you want to collect any data that falls within the category of sensitive personal data, you must obtain this directly from the person that is to whom it relates. So I thought I should mention that. Exactly. So I think there's a question from Nzovu.
Yes.
So I think the principle is you should ask your question, you should answer the question is the purpose for which I'm collecting this data legitimate? Is it lawful? So if you are able to answer that question in the affirmative, then you probably are able to justify a decision to perhaps decline access to a person to your premises. Okay. So I guess that goes to answer that question. But at the end of the day, the data subject has, or rather, the owner of the building has the right of access to their premise, but within the context of legality of that decision. Yeah.
Maybe just to add that there's a bit there about whether the person can claim discrimination if they're denied entry. You see, discrimination arises out of differentiation in treatment. So if everybody accessing the same point is subjected to the same treatment, then it wouldn't be discriminatory. That's the prerogative of the property owner. So discrimination would not apply if everyone is being treated in a similar fashion.
There was a question.
Sorry, just what a bit, Felix, before the next question. I think one of the things that the people forget, and we ask the people to know, is your ability to store that data safely and confidentially. And this is what majority of people who collect data don't think about it. But what we require them that have you put in place the checks and balances that I'll be able to store this data and I have room to store it and I'm able to store it confidentially and to adhere within the law. So that's the first question we want them to answer.
Yeah, and so in that regard also, that what I'm hearing you say as we respond to this question is that as an entity also, you must work hand in hand with your outsourced service providers for them to understand that you have a data protection policy, and these are the safeguards the organization has put within that data protection policy, so that the staff in the outsourced company understand them and implement them. Because when they deal, like for instance, at USIU, you deal with students, you deal with staff, young and old. And so, like Kananu said, people will need to see that this person that is asking me for this information understands why they're asking me for this information and what they are going to do with my information. So that I then cannot say I'm not giving the information. We have to work hand in hand with outsourced service providers for them to understand the kinds of mechanisms or measures we've put in place as far as data protection is concerned, and how they affect access and ingress out of the university. Yeah, thank you. So there was the final, there are 3 questions in the chat, in the Q&A. Somebody is asking whether if their data as a Kenyan citizen is held or stored outside the country, like on cloud, would the Data Protection Act still apply? And then Esther Cheroben, the first question was from Kevin Mureithi. Esther Cheroben has 2 questions. One relates to the requirements, qualifications of a data protection officer, and what would constitute an ideal data protection policy for an organization. Frank Lawrence, the question you've asked was answered earlier on about political parties using our data, where they got it from, how to treat such breach. Yeah, this question was answered earlier on, but Kanan will quickly give you a quick response. Yeah, those are the final questions that we will handle at this point.
All right, so I think I can begin by responding to Kevin's question relating to the transfer of or the storage of an individual's personal data outside of Kenya. In fact, I think it's more or less the case nowadays that most of the data that is stored on the cloud will most likely be stored in a faraway place beyond the reach of the geographical reach where the data subject themselves is located. So generally speaking, the Data Protection Act does not really restrict, the storage of data outside of Kenya, and the regulations provide a bit more detail about that. And this is what they provide. They provide that you can indeed transfer data outside of Kenya, but in certain cases, when you do that, there's a requirement that you retain a copy of that data in locally in Kenya. Okay. Some of the and the regulations set out a very extensive list of such instances, and in the case of USIU in particular, you may want to note that any data that relates to education would have to be you'd have to retain a copy in Kenya. So that's just but an example. Now, when you transfer this data outside of Kenya, you have to comply with certain safeguards that the regulations, the draft regulations set out. One of them is that you must obtain, when you're obtaining the consent from the data subject, when you're collecting the data from them, you must notify them that you're going to, or you're likely to share this data or transfer it outside of Kenya, so that they provide consent to that specifically. The second safeguard requires that as between the person who is transferring this data and the transferee of the data, you should have in place an agreement that, amongst other things, allows the person who is transferring the data to satisfy themselves that you have in place safeguards to secure and process that data securely. Number two, that that particular agreement must also specify the countries where that data can be transferred. So this is something that we will need to bear in mind because this is a specific requirement under the law. The other key requirement is that the transferor of this data must be able to satisfy themselves that the country where this data is being transferred has put in place legal mechanism to protect that data when it is transferred there. And these mechanisms must be at least more or less equal to or better than the safeguards that Kenya has put in place. And the regulations go ahead to provide that a country will be deemed to have met this test if it has, if it's a party to, there's a particular convention that the regulations specify. I just can't remember the name off the top of my head. If that country has a data protection, a sort of reciprocal agreement with Kenya, so this would be a sort of a bilateral agreement. And another instance which I can't remember off the top of my head. So that is the point. So those are some of the safeguards that you just need to bear in mind insofar as the storage of your data as a Kenyan citizen outside of Kenya is concerned.
Okay.
I think there was a question about the requirements for data protection officer. So I don't think we touched on a data protection officer, but the Act does require, because of the nature of the technical nature of data protection issues, it provides certain instances where an organization that processes personal data is required to appoint a person that will ensure that that organization has very good strategies on data protection and that those strategies are adhered to. Now, this person is referred to as a data protection officer. And there are instances where this would be mandatory. So one of them would be where, for example, if you're processing sensitive personal data, you'd be required to have a data protection officer. If you are, as a matter of course, regularly, analyzing data that you collect, you would be required to have a data protection officer. So that just gives you an indication of what the requirement as to having in place a data protection officer looks like. So, and the requirements for one to be a data protection officer would be, you just have to understand what the requirements are under the law, and be able, from a technical point of view, be able to ensure that the organization adheres to the requirements for protecting that data. There was another question, but I can't remember. Yeah.
So simply put, one does not have to hire extra staff to be the data protection officer. You can use somebody who's already there, get them familiar enough, maybe have them work together with the ICT department to safeguard and to hold the organization accountable for the protection of that data.
Yeah, but just to add, Felix, I think we need to be careful because actually as we advance, we'll be able to be catching up with the world. And there are courses on the data protection, certified data protection courses that you'll be required to do. So yes, there are qualifications, the requirement is only that our act is still lenient because it's a little bit new to us. But in a development world, I will not get somebody who did not qualify to be a data protection officer. And for us on the risk perspective, you can't just pick somebody and put him there to mitigate and use that. So there are qualifications, and some even saying you need somebody with the legal, somebody with IT, somebody with understanding on how to store data, like a librarian and things, somebody like that. So yes, our law, when you look at our act, it does not prescribe the actual technical and whatever qualification, but in the world, the actual qualification for that.
I think, George, thank you so much for that. I think one of the things you'll notice with our market, and George, I'm sure you've seen this, and Helen as well. In our market, we've got entities and corporates that will always try to meet up to best practice, and best practice when they look globally to see who has set the standard. And then in our market, again, given how we are segmented, we have the MSME, SME, whom I think the law, what the Kenyan law appreciates is that their uptake or the cost component associated with implementation might be steep. So then there's this phasing, which the law grants some latitude of. My only fear, George, is that now we'll be saying you will not insure MSME and SME.
I would say we may, so long as, you see, they have to meet certain criteria, because what we've realized that people get a driver and call him data protection officer. Even in your imagination, does that person know what to do? And exactly this is what is happening where the data are collected all over the country. People are handling data who does not know the value of the data. They've not taken through those courses. They do not understand what they are doing, but they only know instruction to collect. So that does not qualify you to be a data protection officer.
Okay, thank you, George. We shall not appoint our drivers. Thank you. To be data protection officers. Kananu, do you want to take that question from Frank Lawrence about the political parties? You know how people just woke up one morning. Luckily, I wasn't one of those people. My name was not there in any political party. Yeah, that whole issue. Just before we wind up, if you could take that question and may also respond to what laws govern data collection. 1 minute. The question was, what laws govern data collected through social media from Kenya? That's an anonymous attendee asking that question.
Okay, so yes, I will take that question. In terms of that breach of the data that was then, Kenyans found themselves registered in those parties. This is the unfortunate thing in our country. Maybe fortunate or unfortunate, one can look at it from both sides. Now, the greatest, what shall I say, the entity that collects the greatest amount of data about the subject and retains that information and is likely to abuse that information, in our market, that is the government. In the West, you find that is private sector, your Googles, your Facebooks, and so forth. But in Kenya, it is the government. So there is then a subsidiary question, which is then to what extent can the Data Protection Commissioner hold the other government agencies accountable and responsible for their actions, because that is a role that is charged on the Data Protection Commissioner. So in this instance, the Data Protection Commissioner, after that breach arose where people's data, it doesn't seem clear where that information came from, but the Data Protection Commissioner, I believe, invited people to raise and lodge their complaints. Now, I suspect, and I dare say, quite possibly Kenyans just saw the advert, it was in the newspapers, saw the advert or didn't read the newspaper and therefore did not respond. And you see, then the reality will be the data protection officer will have publicly invited people to complain or to inform, not to complain, but to provide her information off of which investigations and therefore sanctions can be meted. But if the people then do not provide that information, of course, the accusation then will be that her office is not effective and so on and so forth. But the reality is she will not have been provided the information by the public off of which to act. So to Frank's question, there are laws and there are systems and processes within our laws that facilitate raising of issues pertaining the misuse of data by government to that agency. And there is a provision for sanctions that can be meted by that office against the agencies that abuse the information. The real question, like with other agencies, is has that information been provided? Okay, so in that instance, I think, unfortunately, the public did not respond positively to the call for information. Now, to the question by the anonymous attendee about the laws that govern data collected through social media, there is no specific law touching on data collected from social media. However, this Data Protection Act covers information collected from such forums. So it's of broad application, and I like that George also mentioned the Consumer Protection Act. So we operate within a broad framework, and there's also an important act that I need to mention. That is the Kenya Information Communication Act, Information and Communication Act. So that's also a very important law. Actually, it's one of the major laws that governs an entity such as the telcos, for example, Safaricom and Airtel. They're governed by that legislation. So in terms of how they take our data, process our information, that is all contained in that Kenya Information and Communications Act. And the cybercrime, yes, there is the Cybercrimes Act, and
yeah, the computer
so
and
there
cyber
are laws. Yes, so there are laws that govern the entire framework, and it's simply a question of familiarization. But I think the point maybe to the audience is please know your rights and understand that as long as you have a right, you absolutely have a remedy. And that remedy, more often than not, for civil claims is usually monetary compensation or sanction against the person who violated your rights. Thank you, Helen.
Thank you, Kananu. Felix?
Just a quick one.
Yes,
I
yes,
saw this question that we've skipped, and I thought it would be good if I could just very quickly respond to it. There was a question as to that asked what makes a good data protection policy. Yeah. So a data protection policy is a requirement, by the way, under the Act. So if you're handling personal data, you would, as a matter of course, be required to put one in place. What makes a good data protection policy, good? I think the answer depends on what it contains. And provided it addresses the question of what data you are handling, so that you ensure that you customize it and tailor-make it to the particular type of data that you're processing. And then number two, you identify your obligations, in relation to the processing of that data. And number 3, set out the mechanisms that you have put in place to actually protect that data as you process it. And that would make a good data protection policy. It could be a standalone data protection policy, or it could be you could include data protection related provisions within another document. Often it's usually within a privacy policy.
Thank you very much. I want to thank the participants. We had, I think, almost 78 participants at the beginning. Now we have 58, and I want to thank you all for taking time out to attend this webinar. I want to thank my facilitators once again. I usually say these sessions are also opportunities for me and the rest of my team to learn, and we have actually learned a lot.